G'day everyone, and welcome to week 2 of LA 4038 Legal Ethics and Trust Accounting. In the first week of this course, we looked at what it means to be a profession, and then we looked at what we actually mean when we use the word ethics. Part of that description was the fact that ethics go beyond mere compliance with rules. Ethics is also a culture, a way of doing things, the application of the spirit of any rules that are set. In reality, though, ethics in our profession are not simply left to the conscience of each individual lawyer. There are rules. Those rules have two functions. First, they do simply serve as rules. Break them and you're in trouble. Second, however, the rules serve as ethical guidelines. These rules, ethical rules, are not an invitation to march right up to the barest compliance. Instead, when the rules prohibit something, we as practitioners are supposed to see that as a lighthouse. And our intention should be to stay well clear of the rule, not to get as close as we can. As professionals in an ethical profession, we commit to enthusiastically implementing both the letter and the spirit of the ethical rules established for the profession. This week we have 4 videos. In this first one, we look at the Legal Profession Acts, which provide the basic foundation of what society as a whole expects and demands of us as lawyers. In the second video, we take our first look at the Australian Solicitors' Conduct Rules, the fundamental rules for conduct in our profession. In the third video, we look at the equivalent rules for barristers, and we look at the rules of court. Finally, in the fourth video, we look at the work of the Legal Services Commission and the Queensland Law Society's Ethics Centre. The notion of a Legal Profession Act, a piece of legislation intended to govern the legal profession, is not new. In fact, the first Legal Practitioners Act in Queensland was passed in 1882. The current Act, the Legal Profession Act 2007, more or less brought Queensland into line with similar model legislation in other states, although there's currently a renewed push for a new Uniform Legal Profession Act. The 2007 Act is a monster with more than 700 sections. So obviously, in the space of the next 10 minutes or so, I'm not going to do those in too much detail. But in overview, what does the Legal Profession Act actually do? Well, first and foremost, the Legal Profession Act makes it unlawful for a person to engage in legal practice in Queensland unless they are a legal practitioner. We're going to talk more about this shortly. The second thing accomplished by the Legal Profession Act is to set out the process and the criteria for admission as a legal practitioner in Queensland, and the process for obtaining a practicing certificate as a solicitor or as a barrister. We're going to go into a lot of detail on this topic next week, so let's just park it to one side for now. Third, the Legal Profession Act provides the overarching framework for the profession in Queensland. It empowers the Law Society of Queensland for solicitors, and it empowers the Bar Association for barristers, giving each of those organisations the authority that they need in order to regulate their halves of the profession. It sets out a heap of rules for what legal practices need to look like, including, for instance, the rules for incorporated legal practices. Incorporated legal practices are quite a new thing. This is where a corporation is formed and the business of the corporation is legal services. Traditionally, law firms were partnerships, not corporations. We still hear of people calling themselves partners, whereas in fact, in a large number of legal practices now, they're actually company directors. Finally, the Legal Profession Act spends pages and pages and pages, more than half its length, setting out rules for how lawyers and law firms may charge clients, how they must communicate with clients about costs, how clients can challenge those costs, and generally protecting the community against overcharging by legal practitioners. For our purposes, looking at ethics, The key function of the Legal Profession Act is that it reserves legal practice only for those who have been admitted before an Australian court and who also hold a practicing certificate. Now, there are some relatively minor exceptions. For instance, government lawyers who work as public servants are not required to have practicing certificates, but at the same time, they can't appear in court. So if you want to be able to do all the things that a lawyer can do in Australia, you need to be admitted and you need a practicing certificate. Without those, you can't engage in legal practice. No matter how much you know about the law, you can't do it. You might have a cracking first-class honours degree in law, doesn't matter. You might have worked as a paralegal for 20 years and forgotten more about law than most junior solicitors know, doesn't matter. If you're not admitted before a court and you don't hold a practicing certificate, you can't practice as a lawyer. Believe it or not, this measure is not intended for the protection of lawyers. It's not intended to give lawyers protection from outside competition. Rather, this measure is for the protection of the community. It means that if a member of the community goes along to see a lawyer, they know that the lawyer has received the proper training, that they've been considered suitable for admission, that they are bound by all the rules we're talking about this week, that they are insured, that they complete compulsory professional development. All these things are for the protection of the community. There's an instructive West Australian case called the Legal Practice Board against Ryder. Ryder was clearly a very intelligent man, but also clearly unprincipled. He opened offices in Perth, put a wig and robe on display, and started practicing as a lawyer. And he got away with it for some time, once even appearing in the Supreme Court. And by all accounts, he seems to have done an okay job. It all came tumbling down, but not due to angry clients. They seemed happy enough. How remarkable for someone to pull off such a deception. The court was unamused though, and Ryder was sentenced to 20 months in prison for his deception. So what does it mean to say that you cannot engage in legal practice? What is engaging in legal practice? The rules were effectively set out in a case called Cornell and Nagel by Justice J.D. Phillips, who said that legal practice goes beyond things that are specifically reserved for lawyers. A person can engage in legal practice by doing something which, though not required to be done exclusively by a solicitor, is usually done by a solicitor, and by doing it in such a way as to justify the reasonable inference that the person doing it is a solicitor. That's a pretty broad definition. Putting it in ethical terms, if you don't hold a practicing certificate in Australia, don't do anything that even might plausibly be considered engaging in legal practice. Stay well clear, because the line is hazy. A good example to look at is a case called the New South Wales Bar Association against Davison. Davison was a barrister who lost his practicing certificate in 2001 during a scandal about the failure of barristers to pay income tax. Prior to this, he had practiced extensively in local government, environment law and planning law. And so once he could no longer practice as a barrister, he set himself up as a consultant, providing advice on town planning matters. In reality, though, he was really doing the same stuff he'd always done. By giving advice about town planning matters, he was really giving legal advice about planning law. Just calling yourself a consultant instead of a barrister doesn't actually change anything. No one was fooled, and he was restrained from continuing his practice. This whole question of practicing without a certificate is especially problematic for law students. Even a relatively junior law student knows far more about the law than most people in society. And because lawyers are expensive, family and friends and randos on the bus for that matter may ask you for help. And sometimes you really want to help, especially if you think you know the answer. You've been studying for years and you can finally see a legal problem, a real one, where you can help. So tempting. Don't do it. If you don't stay well clear, you may inadvertently engage in legal practice. In all honesty, You're not likely to go to jail the way Ryder did, but you may put your own admission at risk. What a waste to do all that study and not end up as a lawyer. So, the Legal Profession Act is 700 sections long, and I've talked about one. But it's super important. The Legal Profession Act reserves legal practice for lawyers only. It sets out the rules for admission. It empowers the Law Society and Bar Association. It sets up rules for how law firms must operate, and it sets out rules for the financial relationship between lawyers and their clients. It is the key piece of legislation by which the community, through the Parliament, tells the profession how we must be structured and how we must act. Almost everything else in this course ultimately flows in one way or another from the heads of power under the Legal Profession Act. Okay, that's enough Legal Profession Act for now. In the second video, it's down to the nitty-gritty, the Australian Solicitors' Conduct Rules. These are the rules that bind all solicitors. We're going to spend weeks looking at them. But in video 2, we'll take a broad overview. See you there.